Welcome to another deep dive. Today, we're exploring some really interesting excerpts from a Senate hearing. This one features Judge Neil Gorsuch.
That's right.
And our mission here, it's not just about breaking down complex legal ideas.
No, definitely not.
We're aiming to, uncover some insights into judicial temperament, maybe how relevant these foundational documents still are, and, well, there are even some pretty surprising personal stories in here.
Huh.
Think of it as your shortcut to getting really well-informed on stuff that, honestly, impacts all of us.
And yeah, well, we'll definitely get into some, let's say, weighty topics. The insights here are pretty universal, I think.
Right.
It's not just for lawyers. It's more about understanding how big ideas get formed, how they're debated, and importantly, how these complex concepts often have roots in really relatable human experiences.
Okay, let's unpack this then. We should probably kick off with something pretty unexpected. It really sets a certain tone. This exchange between Judge Gorsuch and Senator Ted Cruz. Cruz asks him, what is the answer to the ultimate question of life, the universe, and everything?
Yes. And Gorsuch says...
That's 42.
Right. The Hitchhiker's Guide to the Galaxy. Classic.
Exactly. And Gorsuch explains it's kind of a family joke he uses. Mostly, it seems, to put nervous young law clerks at ease when they're getting sworn in.
That's actually pretty clever. A bit of levity.
Yeah, it's not just, a quirky little detail. It feels like a lesson, maybe. That even these really sharp legal minds see the value in human connection, de-stressing people in these intense moments.
Definitely. It reveals a bit about valuing empathy alongside that legal sharpness.
Totally. And speaking of influences, that brings us to Justice Byron White.
Mm-hmm. Gorsuch clerked for him.
Right. He calls it the privilege of lifetime. Says White was his childhood hero.
And Justice White's background is, well, it's really something. Pretty unique.
How so?
Well, okay, he was the only Supreme Court justice appointed by JFK. He's also the only one ever to have led the NFL in rushing yards.
Wait, seriously? Led the NFL?
Yep. And on top of that, graduated first in his class from Yale Law School.
Wow. Okay, that is a unique background.
A very multifaceted guy.
And Gorsuch talks quite a bit about White's real humility, his approach to law. What did that actually look like day to day? Why did it stick with Gorsuch so much?
Well, Gorsuch describes this habit White had. He'd just sort of wander into the clerk's office, maybe start with a grunt.
Okay.
And then ask something like, so what does the great Justice Gorsuch think about this one?
Putting him on the spot.
Yeah, apparently he expected you to have an opinion on, pretty much anything. But he wouldn't show his own cards right away.
Interesting.
He'd chuckle, walk out, and, as Gorsuch puts it, bounce ideas off this know-nothing 20-year-old kid.
That kind of interaction, it really says something about White's whole philosophy, doesn't it?
It does. His philosophy was simply to decide cases.
Which sounds basic.
Yeah, many thought it was, mundane, maybe even a bit dishonest. But Gorsuch saw genuine humility there.
Why humility?
Because White had been a, quote, workaday lawyer for 14 years. Trying cases, big and small. He knew firsthand, Gorsuch says, how hard it is to have all the answers when you're actually arguing a case in court.
Okay, that makes sense. It wasn't about not having deep thoughts, but about appreciating the difficulty.
Exactly. Wisdom isn't always having the answer yourself. Maybe it's knowing how hard the answers are to find and being open.
Right. And, okay, we have to touch on the Supreme Court basketball court story.
Oh, yeah. The highest court in the land. Literally.
Huh. And Justice White, the former NFL star, playing legendary games there, against Gorsuch's term, pencil neck law clerks.
Apparently he had legendary elbows and fouls. You can just picture it, right? An NFL Hall of Famer schooling these clerks.
Totally.
And even when he was in his 70s, he'd apparently come back for reunions and play horse with his former clerks.
Still got it, huh?
Yeah, Gorsuch mentioned his eye-hand coordination was uncanny. Had this weird free throw shot, back up over his head that you could just sink consistently.
Incredible. But there's a more poignant moment Gorsuch shares, too, about walking with Justice White in the court's basement.
Right, past the portraits of the former justices.
Yeah. And White asks Gorsuch how many he recognizes. Gorsuch admits, even as a clerk, maybe about half.
And White.
White just says humbly, me too, and then adds, the truth is, we'll all be forgotten soon enough, me included.
Wow. That's quite a moment.
Yeah.
What's really fascinating there is the depth of that humility. Gorsuch says he couldn't believe it at the time, that one of the greats could be forgotten.
But,
as Gorsuch points out, Justice White's portrait, it now hangs down in that very basement.
A powerful reminder.
Absolutely.
Yes.
Perspective, and maybe that kind of humility connects to how one approaches interpreting the law itself.
That's a really good link. Let's shift gears then to a weightier topic, one where that humility might actually inform the approach.
Okay.
The whole debate around originalism. In the hearing, some Democratic senators were calling it things like quaint and outdated.
Right. It's often set up as these two opposing views, isn't it?
Yeah, like on one hand, the idea of a living, breathing, changing document, the Constitution flexible enough maybe for judges to reach certain policy outcomes they prefer.
Versus the idea that a judge has to follow the text, but follow it as informed by the original understanding back when it was written.
Right. So what's Gorsuch's perspective on this?
Well, his take is pretty interesting. He suggests that using labels like originalism negatively is sometimes just an excuse for engagement with the ideas themselves.
Like dismissing it without grappling with it.
Kind of. He argues that basically every judge alive wants to understand what a legal text originally meant. It's not inherently, an ideological thing for him.
And by original understanding, what exactly do we mean there?
It generally means looking at how the words in a law or the Constitution would have been understood by people at the time it was actually adopted.
Yeah.
You look at historical documents, how words were used then, that sort of thing.
Gotcha. And he gives examples, right, to show it's not just one side of the aisle using this.
Yeah, several compelling ones. He mentions Jones, that was the GPS tracking case.
Right, whether putting a tracker on a car is a search.
Yep. And Kylo, the thermal imaging case, is using a thermal imager to scan a house, a search.
Okay.
He also points to Crawford, which is about the Sixth Amendment right to confront witnesses against you in court.
Mm-hmm.
And he even mentions Justice Stevens looking deeply into the Fifth Amendment's history, Chief Justice Warren in Powell v. McCormack.
Which was about Congress excluding a member.
Exactly. And even the big Second Amendment case, Heller. Gorsuch points out that both Justice Scalia in the majority and Justice Stevens dissenting relied heavily on looking at the original history.
So different conclusions, but similar method in that respect.
Precisely. And interestingly, Justice Kagan, during her own confirmation hearing, apparently said something very similar.
Oh, yeah.
Along the lines of, we're all originalists in this sense. Meaning, at a basic level, judges try to apply what they say, what they meant to do.
Okay, let's dig into that Kylo case a bit more. Thermal imaging. That seems like a perfect example for this debate.
It really is.
Yeah.
Because, obviously, the framers in the 1700s couldn't possibly have imagined thermal imaging technology.
Right. So how does originalism handle that?
Well, Justice Scalia, who was probably the most prominent originalist on the court then, wrote the majority opinion. It was 5-4, and Justice Thomas joined him.
And they found
the Fourth Amendment did apply. Scalia basically compared using the thermal imager from outside the home to, like, historical peeping toms, applying the old principle to new tech.
Huh. And Stevens dissented on that one.
He did, which just shows, it's complex. Even people aiming for a similar interpretive goal can reach different outcomes on these tough new questions.
So connecting this back to the bigger picture, Gorsuch's point seems to be that judges are trying to apply the law based on that original understanding, not just what they wished the law said.
Exactly. He brings up James Madison and the idea of a fixed meaning canon of construction. The idea is that the Constitution needs a stable, consistent meaning, not one that just shifts with, societal whims or political whims.
The disagreements aren't necessarily political.
Gorsuch argues they're disagreements over what the law is, not a fight about politics and judicial robes.
And this ties into fairness too, right? Due process, fair notice.
Absolutely.
Yeah.
The idea that if your liberty, your property, can be taken based on how a law is interpreted.
You should be able to know what that law means beforehand. Seems fundamental.
It does. Which brings us to another really fascinating case Gorsuch discussed, the Fish case.
The Fish case. Okay, tell me more.
It's Yates v. United States. Yeah. And the issue was a law aimed at things like the Enron scandal, destroying evidence. It criminalized destroying documents or other tangible objects when law enforcement is investigating.
Okay, tangible objects. Seems broad. What happened?
A fisherman was caught with undersized fish. The feds told him to bring the fish back to port. Instead, he allegedly told his crew to throw them overboard.
Ah. So were the fish tangible objects under that statute?
That was the exact question, and the court split in a really unexpected way.
How so?
Justice Ginsburg wrote the majority opinion. Justice Alito concurred separately. They essentially said, no, fish aren't covered. Look at the context. The law was about shredding documents, deleting emails, not, fish.
Okay, context matters.
Hmm.
But who dissented?
Justice Kagan wrote the dissent, joined by Justice Scalia.
Kagan and Scalia together.
Yep. They argued, look, the text says tangible objects. Fish are tangible. They are objects. The fisherman knew what he was doing was wrong. The law gave him notice.
Wow. That is an unexpected lineup. Ginsburg and Alito versus Kagan and Scalia.
Exactly, Gorsuch's point. He says this case divided in a way that people don't expect.
So it shows interpretation isn't just like a simple left-right thing.
Not at all. It reinforces his view that judges are grappling with what we think the law is based on text, context, history, whatever tools they use, not just voting for what we would like the outcome to be.
It's a pursuit of meaning, basically.
That seems to be the idea.
Okay, let's move on slightly. The Federalist Society came up in the hearing, too.
Mm-hmm. Portrayed by some Democrats as nefarious.
Right. Senator Cruz pushed back, doing a self-report, saying he'd been a member since he was 21, pointing out it has like 60,000 members.
And the society's stated purpose, according to the hearing material, is pretty clear.
Which is?
Basically, it's founded on the principles that the state exists to preserve freedom, that the separation of governmental power is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is not what it should be.
Okay. Pretty standard constitutional principles, it sounds like.
Seems so.
And Gorsuch's involvement, he said it's pretty limited, right? Like one event a year.
Yeah, about that much. But he did give a speech at one of their events that touched on something really interesting. Over-criminalization.
Over-criminalization, meaning...
Right. Meaning just.
Yeah.
Too many criminal laws. The numbers he cited are kind of staggering.
Like what?
Okay, so there are about 5,000 federal criminal laws actually passed by Congress. But then, buried in federal regulations, there are an estimated, get this, 300,000 potential criminal offenses.
300,000 in regulations.
That's the estimate Gorsuch mentioned. He said scholars basically gave up trying to count them all.
That's mind-boggling. He brought up some history on this too, didn't he?
Yeah, James Madison warning about having too many laws. Compared it to the Roman Emperor Caligula.
Caligula? How?
Apparently, Caligula used to post the laws way up high in tiny print, just to keep people guessing, keep them on their toes, effectively making everyone a potential lawbreaker.
So an ancient problem with very modern numbers.
Pretty much. And it loops back to that idea of due process and fair notice again.
Right. How can you have fair notice if there are 300,000 potential traps hidden in regulations?
Exactly. There's that saying Gorsuch mentioned. In heaven, there is no law. In hell, there is nothing but law, and due process is meticulously obeyed.
The challenges for the, honest citizen, how do you navigate that massive landscape without accidentally tripping over something?
It's a huge question. Makes you wonder.
Definitely. Okay, another area where Gorsuch faced questions was about corporations and the First Amendment.
Ah, yes. Cases like Citizens United or Hobby Lobby often come up here.
Right. The criticism being that corporations shouldn't have free speech rights like people do. But Gorsuch kind of flipped the question, didn't he?
He did. He essentially asked, well, okay, think about the New York Times. It's a corporation. Does anyone credibly argue it doesn't have First Amendment protection?
Good point. Or the NAACP, another example he might use, also a corporation.
It's exactly. Gorsuch stated it's long-settled precedent that corporations, whether it's the NRA, the ACLU, the Sierra Club, big book publishers like Simon & Schuster, they do have First Amendment protections.
And the reasoning behind that?
The idea is that protecting their speech fosters a robust arena of free speech overall. It allows all sorts of organizations, not just individuals, to participate in public debate, contribute ideas, advocate for causes.
So it's less about the corporate form itself and more about protecting the speech and the debate.
That seems to be the core principle, ensuring a wide range of voices can be heard in the public square.
Makes sense when you put it that way. Okay, so we've covered a lot of the legal philosophy, the humility, the interpretation debates, but we also got some lighter moments, glimpses into Gorsuch's life outside the courtroom.
We did, like the Denver rodeo tradition.
Right. He takes his law clerks, especially ones maybe not from the American West, to the National Western Stock Show and Rodeo in Denver.
Sounds like quite an experience.
Yeah.
He described the cattle drive right down 17th Street.
Yeah. So it's like Denver's Pennsylvania Avenue, and the prize steer apparently gets to hang out in the lobby of the fancy Brown Palace Hotel.
Huh. Like the Willard or the Plaza, he said. A steer in the lobby. Only at the rodeo.
Exactly. And then there was mutton busting.
Ah, yes. Mutton.
He called it bronco busting for adults, except it's a poor little kid clinging to a sheep.
Did he give riding advice?
Said he tells his kids to hold on monkey style, but apparently his daughters still have PTSD from getting knocked around pretty good when they did it.
Oh, dear. Well, it's certainly a memorable family activity. A reminder that judges are people, too, with slightly hazardous family traditions sometimes.
Frankly, it grounds everything a bit.
You know, looking back at this whole hearing through these excerpts, it really has been quite a deep dive. We've seen insights not just into, legal thinking and how the judiciary works,
Right.
but also into things like humility, human nature, and just the unexpected ways legal ideas connect with real life, everyday life sometimes.
Absolutely. It covers a lot of ground. And maybe a final thought for you listening.
Hmm.
When you think about how judges, like the ones we've talked about, have to grapple with these huge, complex legal questions, applying principles written centuries ago to our world today,
Yeah.
how does that change how you think about fairness or justice and how it actually works in practice?
That's a great question to ponder.
Something to think about. Thanks so much for joining us on this deep dive today.